outpatient competency restoration. And if that's something that can be arranged, that Ms. Huerta can attend those and would be a client of South Central, then I know that they can do outpatient competency restoration just because I've done it before.
And
well, I think we've had a client before that has done that as well because we couldn't get him into the hospital. Mr. Regier?
And Your Honor, again, the state does have significant concerns regarding any modifications to the bonds previously ordered by the court in the current case, both because of the nature of these two cases, the allegations in the request for revocation in the 2022 case, the fact that this defendant does have at least 16 prior failures to appear, and the fact that it is the state's understanding that the alleged victim is the same victim in both the 2022 and the 2024 case. So again, for all those reasons, the state.
Mr. Regier, as I recall from the jury trial that almost went, that was her father, is that right?
That is the state's understanding based off of a previous review of the case, Your Honor. And for all those reasons, the state is again renewing its objections to any modifications to the bonds currently established by the court in the current case. And the state does consider the court's prior orders insofar as competency are concerned to be valid and continuing in this matter.
Well, I do recall the father's statement to the court at sentencing that was, well, it's still with me. So that says something about the statement and the defendant.
And Your Honor, I guess I would just say, for what it is worth, the new charge occurred prior to the trial and sentencing that for what was the probation revocation. It just, the new case was not charged until after her conviction and sentencing, but the incident itself occurred prior to her conviction and sentencing and being placed on probation. So I just want to say this is not a situation where after she was convicted and sentenced, placed on probation, that she was alleged to have then violated the protective order and have a new charge from that. This is pre-existing.
I am going to continue the case, both cases. I'm not going to modify the bond neither today, but if Mr. Regier or Mr. Patterson, let me just do it this way. If Mr. Patterson can get some kind of professional report from the local mental health on what their position is, because I know they're familiar with this lady, if they could provide a recommendation and an explanation of how they could serve her, I would consider that. I'm not saying that it would be dispositive of the bond issue because Ms. Huerta's a real risk of attending. But let's see, continue this about, is 60 days too far out?
I know that my client would ask for it to be as soon as possible just because of her wanting to try to get out of custody as soon as possible.
Well, I can't hear her case though until she's got her competency restored, ma'am.
If I was to agree to GPS monitoring, would we then be able to go ahead?
Haven't we tried that before?
Never have I tried that. I've never been on GPS monitoring, not once.
And this relative that you're talking about is so remotely removed. Is that your child's dad's sister?
Yeah, his sister-in-law.
His sister-in-law.
But I'm able to get my own housing. I was even going to see if maybe I could get either sober living or MHA housing, but I can get a regular apartment because I have the funds available to do so.
I'm only considering this because I have a real problem with mentally ill being held in jail without the care they need. But I also want to know what, Mr. Regier, if you want to respond with, if they do remotion this again with a complete plan of where she'd live, what treatment she'd get, if you wanted to respond with when she could realistically get into treatment and further evaluation. That would help because I have a real problem turning her loose with her history. But on the other hand, I don't want a mentally ill person just sitting there indefinitely either. So I'm going to continue this, and I guess the ball will be on the defendant to cooperate to get whatever she needs to convince the court that she won't be a threat to society and that she will be in court. And that's going to be a real task, Ms. Huerta, because you have not given much faith to the court based on your past conduct.
Right, but I haven't violated my. Go ahead.
But I thank you. Thank you for giving me that authority. That was sarcasm if you didn't catch that, Ms. Huerta. Okay. I'm going to leave it at that. We'll be adjourned. You may.
Your Honor, we need a new court date.
Oh, we do. She got me sidetracked. Okay. Not Missy, Jen. I'm still thinking it'll be 60 days before she gets a bed, but if you want to give me 30, that'll be all right. If you have 30, but you probably don't.
One moment, Your Honor, I'm looking.
Okay.
We could do August 18th.
What tasks do you need me to do to be able to demonstrate to you to be able to get the bond reduction?
Kristen, I'll be taking care of that, okay?
You will.
And August 18th does work on my calendar, Your Honor.
Okay, this matter is continued to August 18th at 9 a.m. Now, if there's nothing further, Ms. Huerta, you are remanded to the custody of the sheriff at this time. In other words, you may go. Deputy, do you have anyone else there?
I do not, Your Honor.
Thank you. Mr. Bauer, do you have anyone else?
I do not have anyone else, Your Honor. Maybe.
All right, let's talk about that. The hearing with Judge Webster gave us a lot to consider, especially around the intersection of mental health, public safety, and how hard it can be for the court to strike the right balance. At the center of this hearing was defendant Kristen Whitta, facing multiple legal hurdles, including a recent charge and a probation revocation from an earlier case. But the real challenge wasn't just legal, it was clinical. Judge Webster spent much of the hearing wrestling, in real time, with the complexity of holding a mentally ill defendant who hasn't yet been restored to competency. What stood out was how much care he took in walking that tightrope. He was respectful but direct, acknowledging the risks while still clearly uncomfortable with the idea of warehousing someone who might need psychiatric support more than incarceration. At one point, he flatly stated that he has a real problem with mentally ill being held in jail without the care they need, and honestly, that's a moment of refreshing judicial candor. Kristen herself was engaged, emotionally, and made several appeals directly to the court, offering housing alternatives and even suggesting GPS monitoring. She insisted she had never been on tether before and seemed ready to comply. But Judge Webster, weighing that against her record's 16 prior failures to appear and an alleged pattern involving the same victim, wasn't buying it just yet. He wasn't dismissive, but he was grounded. Even when Kristen interrupted and sprinkled in a little sarcasm, "Thank you for giving me that authority," Judge Webster kept his cool. He didn't bite, didn't escalate, just moved on and focused on the next legal step. Defense counsel tried to offer practical pathways for release, including outpatient competency restoration programs through South Central, while the prosecutor pushed back, highlighting the defendant's lengthy history of noncompliance and the serious nature of the allegations. Both sides were doing their jobs, nothing flashy, but competent and steady. Ultimately, Judge Webster made the call to continue the case to August 18th, leaving the door open for the defense to return with a more detailed treatment and housing plan. He wasn't saying no forever, he just wanted something that could give the court confidence that Kristen wouldn't be a risk or disappear. The whole atmosphere felt serious but human. The judge clearly understood the stakes. And while he wasn't about to hand out freedom lightly, you could sense that he wasn't comfortable with unnecessary incarceration either. It was a courtroom grappling with real-world limits, trying to do the right thing within the structure it has. And that's the kind of hearing that sticks with you not because of fireworks, but because of the restraint it takes to pause, ask for more information, and hold the line with compassion. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.